The False Claims Act is an American federal law that imposes liability on persons and companies who defraud governmental programs. It is the federal government's unregistered trademark's primary litigation tool in combating fraud against the government. The law includes a key Tam provision that allows people who are not affiliated with the government, called relators under the law, to file actions on behalf of the government. Persons filing under the Act stand to receive a portion of any recovered damages. As of 2012, over 70% of all federal government FCA actions were initiated by whistleblowers. Claims under the law have typically involved healthcare, military, or other government spending programs, and dominate the list of largest pharmaceutical settlements. The government recovered $38.9 billion under the False Claims Act between 1987 and 2013, and of this amount, $27.2 billion or 70% was from key Tam cases brought by relators. History: key Tam laws have history dating back to the Middle Ages in England. In 1318, King Edward II offered one-third of the penalty to the relator when the relator successfully sued government officials who moonlighted as wine merchants. The Maintenance and Embracery Act 1540 of Henry VIII provided that common informers could sue for certain forms of interference with the course of justice in legal proceedings that were concerned with the title to land. This act is still enforced today in the Republic of Ireland, although in 1967 it was extinguished in England. The idea of a common informer bringing suit for damages to the Commonwealth was later brought to Massachusetts, where penalties for fraud in the sale of bread are to be distributed one-third to inspector who discovered the fraud and the remainder for the benefit of the town where the offense occurred. Other statutes can be found on the colonial law books of Connecticut, New York, Virginia and South Carolina. The American Civil War was marked by fraud on all levels, both in the Union North and the Confederate South. During the war, unscrupulous contractors sold the Union Army decrepit horses and mules in ill health, faulty rifles and ammunition, and rancid rations and provisions, among other unscrupulous actions. In response, Congress passed the False Claims Act on March 2, 1863, 12 Stat. 696. Because it was passed under the administration of President Abraham Lincoln, the False Claims Act is often referred to as the Lincoln Law. Importantly, a reward was offered in what is called the key Tam provision, which permits citizens to sue on behalf of the government and be paid a percentage of the recovery. Key Tam is an abbreviated form of the Latin legal phrase key Tam pro domino rege quam pro se ipso in hac parts equitor. In a key Tam action, the citizen filing suit is called a relator. As an exception to the general legal rule of standing, courts have held that key Tam relators are partially assigned a portion of the government's legal injury, thereby allowing relators to proceed with their suits. U.S. Senator Jacob M. Howard, who sponsored the legislation, justified giving rewards to whistleblowers, many of whom had engaged in unethical activities themselves. He said, "I have based the key Tam provision upon the old-fashioned idea of holding out a temptation, and setting a rogue to catch a rogue, unregistered trademark which is the safest and most expeditious way I have ever discovered of bringing rogues to justice. In the massive military spending leading up to and during World War II, the U.S. Attorney General relied on criminal provisions of the law to deal with fraud, rather than using the FCA. As a result, attorneys would wait for the Department of Justice to file criminal cases and then immediately file civil suits under the FCA, a practice decried as parasitic at the time. Congress moved to abolish the FCA but at the last minute decided instead to reduce the relator's share of the recovered proceeds. The law was again amended in 1986, again due to issues with military spending. Under President Ronald Reagan's military buildup, reports of massive fraud among military contractors had become major news, and Congress acted to strengthen the FCA. The law has always primarily been used against defense contractors, but by the late 1990s, healthcare fraud began to receive more focus, accounting for approximately 40% of recoveries by 2008. Franklin v. Park Davis, filed in 1996, was the first case to apply the FCA to fraud committed against the government. due to bills submitted for payment by Medicaid/Medicare for treatments that those programs do not pay for as they are not FDA approved or otherwise listed on a government formulary. FCA cases in the field of healthcare are often related to off-label marketing of drugs by drug companies, which is illegal under a different law, the Federal Food, Drug, and Cosmetic Act. The intersection occurs when off-label marketing leads to prescriptions being filled and bills for those prescriptions being submitted to Medicare/Medicaid. As of 2012, over 70% of all federal FCA actions were initiated by whistleblowers. The government recovered $38.9 billion under the False Claims Act between 1987 and 2013, and of this amount, $27.2 billion or 70% was from key TAM cases brought by relators. In 2014, whistleblowers filed over 700 False Claims Act lawsuits. Provisions: the Act establishes liability when any person or entity improperly receives from or avoids payment to the federal government. The Act prohibits knowingly presenting, or causing to be presented a false claim for payment or approval. Knowingly making, using, or causing to be made or used, a false record or statement material to a false or fraudulent claim. Conspiring to commit any violation of the False Claims Act. Falsely certifying the type or amount of property to be used by the government. Certifying receipt of property on a document without completely knowing that the information is true. Knowingly buying government property from an unauthorized officer of the government, and knowingly making, using, or causing to be made or used a false record to avoid, or decrease an obligation to pay or transmit property to the government. Certain claims are not actionable, including certain actions against armed forces members, members of the United States Congress, members of the judiciary, or senior executive branch officials. Claims, records, or statements made under the Internal Revenue Code of 1986 which would include tax fraud. There are unique procedural requirements and False Claims Act cases. For example, a complaint under the False Claims Act must be filed under seal. The complaint must be served on the government but must not be served on the defendant. The complaint must be buttressed by a comprehensive memorandum, not filed in court, but served on the government detailing the factual underpinnings of the complaint. In addition, the FCA contains an anti-retaliation provision, which allows a relator to recover, in addition to his award for reporting fraud, double damages plus attorney fees for any acts of retaliation for reporting fraud against the government. This provision specifically provides relators with a personal claim of double damages for harm suffered and reinstatement. Under the False Claims Act, the Department of Justice is authorized to pay rewards to those who report fraud against the federal government and are not convicted of a crime related to the fraud, in an amount of between 15 and 25% of what it recovers based upon the whistleblower's report. The relator's share is determined based on the FCA itself, legislative history, Department of Justice guidelines released in 1997, and court decisions. 1986 changes, False Claims Act amendments, the elimination of the government possession of information bar against key TAM lawsuits. The establishment of defendant liability for deliberate ignorance, and reckless disregard of the truth. Restoration of the preponderance of the evidence standard for all elements of the claim including damages. Imposition of treble damages and civil fines of $5,000 to $10,000 per false claim. Increased rewards for key TAM plaintiffs of between 15% and €30% of the funds recovered from the defendant. Defendant payment of the successful plaintiff's expenses and attorney's fees, and employment protection for whistleblowers including reinstatement with seniority status, special damages, and double back pay. 2009 changes. On May 20, 2009, the Fraud Enforcement and Recovery Act of 2009 was signed into law. It includes the most significant amendments to the FCA since the 1986 amendments. FERA enacted the following changes: expanded the scope of potential FCA liability by eliminating the presentment requirement. Redefined claim under the FCA to mean any request or demand, whether under a contract or otherwise for money or property, and whether or not the United States has title to the money or property that is presented directly to the United States, or to a contractor, grantee, or other recipient, if the money or property is to be spent or used on the government's behalf or to advance a government program or interest, and the government provides or reimburses any portion of the requested funds. Amended the FCA's intent requirement, and now requiring only that a false statement be material to a false claim. Expanded conspiracy liability for any violation of the provisions of the FCA. Amended the reverse false claims provisions to expand liability to knowingly and improperly avoid, ing or decrease, ing an obligation to pay or transmit money or property to the government. Increased protection for key TAM plaintiffs relators beyond employees, to include contractors and agents. Procedurally, the government's complaint will now relate back to the key TAM plaintiff relators filing. Provided that whenever a state or local government is named as a co-plaintiff in an action, the government or the relator shall not be preclude, d. from serving the complaint, any other pleadings, or the written disclosure of substantially all material evidence. Increased the Attorney General's power to delegate authority to conduct civil investigative demands prior to intervening in an FCA action. With this revision, the FCA now prohibits knowingly submitting for payment or reimbursement a claim known to be false or fraudulent. Making or using a false record or statement material to a false or fraudulent claim or to an obligation unregistered trademark to pay money to the government. Engaging in a conspiracy to defraud by the improper submission of a false claim. Concealing, improperly avoiding or decreasing an obligation unregistered trademark to pay money to the government. 2010 changes under the Patient Protection and Affordable Care Act. On March 23, 2010, the Patient Protection and Affordable Care Act was signed into law by President Barack Obama. The Affordable Care Act made further amendments to the False Claims Act, including changes to the public disclosure bar. Under the previous version of the FCA, cases filed by private individuals or or relators could be barred if it was determined that such cases were based on a public disclosure of information arising from certain proceedings, such as civil, criminal or administrative hearings, or news media reports. As a result, defendants frequently used the public disclosure bar as a defense to a plaintiff for unregistered trademark's claims and grounds for dismissal of the same. PPACA amended the language of the FCA to allow the federal government to have the final word on whether a court may dismiss a case based on a public disclosure. The language now provides that a court shall dismiss an action unless opposed by the government, if substantially the same allegations or transaction alleged in the action or claim were publicly disclosed C 31 U.S.C. 3730, E, 4, A. Original source requirement. A plaintiff may overcome the public disclosure bar outlined above if they qualify as an original source, the definition of which has also been revised by PPACA. Previously, an original source must have had direct and independent knowledge of the information on which the allegations are based. Under PPACA, an original source is now someone who has knowledge that is independent of and materially adds to the publicly disclosed allegations or transactions. C 31 U.S.C. 3730, E, 4, B. Overpayments. FERA redefined obligation under the FCA to include retention of any overpayments. Accordingly, such language imposed FCA liability on any provider who received Medicare and Medicaid overpayments and fails to return the money to the government. However, FERA also raised questions as to what exactly is involved in the retention of overpayments. For example, how long a provider had to return monies after discovering an overpayment. PPACA clarified the changes to the FCA made by FERA. Under PPACA, overpayments under Medicare and Medicaid must be reported and returned within 60 days of discovery, or the date a corresponding hospital report is due. Failure to timely report and return an overpayment exposes a provider to liability under the FCA. Statutory anti-kickback liability. The Federal Anti-Kickback Statute, 42 U.S.C. 1320A7b, b, is a criminal statute which makes it improper for anyone to solicit, receive, offer or pay remuneration in exchange for referring patients to receive certain services that are paid for by the government. Previously, many courts had interpreted the FCA to mean that claims submitted as a result of AKS violations were false claims and therefore gave rise to FCA liability. However, although this was the A-O majority rule among courts, there were always opportunities for courts to hold otherwise. Importantly, PPACA changed the language of the AKS to provide that claims submitted in violation of the AKS automatically constitute false claims for purposes of the FCA. Further, the new language of the AKS provides that a person need not have actual knowledge or specific intent to commit a violation of the AKS. Accordingly, providers will not be able to successfully argue that they did not know they were violating the FCA because they were not aware the AKS existed. Practical application of the law. The False Claims Act has a detailed process for making a claim under the Act. Mere complaints to the government agency are insufficient to bring claims under the Act. A complaint must be filed in U.S. District Court in camera. After an investigation by the Department of Justice within 60 days, or frequently several months after an extension is granted, the Department of Justice decides whether it will pursue the case. If the case is pursued, the amount of the reward is less than if the Department of Justice decides not to pursue the case and the plaintiff later continues the lawsuit himself. However, the success rate is higher in cases that the Department of Justice decides to pursue. Technically, the government has several options in handling cases. These include intervene in one or more counts of the pending Tam action. This intervention expresses the government unregistered trademark's intention to participate as a plaintiff in prosecuting that count of the complaint. Fewer than 25% of filed Tam actions result in an intervention on any count by the Department of Justice, decline to intervene in one or all counts of the pending Tam action. If the United States declines to intervene, the relator may prosecute the action on behalf of the United States, but the United States is not a party to the proceedings apart from its right to any recovery. This option is frequently used by relators and their attorneys, move to dismiss the relator unregistered trademark's complaint either because there is no case, or the case conflicts with significant statutory or policy interests of the United States. In practice, there are two other options for the Department of Justice: settle the pending Tam action with the defendant prior to the intervention decision. This usually, but not always, results in a simultaneous intervention and settlement with the Department of Justice. Advise the relator that the Department of Justice intends to decline intervention. This usually, but not always, results in dismissal of the Tam action, according to the U.S. Attorney's Office of the Eastern District of Pennsylvania. There is case law where claims may be prejudiced if disclosure of the alleged unlawful act has been reported in the press, if complaints were filed to an agency instead of filing a lawsuit, or if the person filing a claim under the act is not the first person to do so. Individual states in the U.S. have different laws regarding whistleblowing involving state governments. Taxation of awards under FCA in the U.S. The U.S. Internal Revenue Service treats Tam payments to a relator under FCA as ordinary income and not as capital gains. The IRS's position was challenged by a relator in a case called Alderson v. United States, and in 2001 the Circuit Court upheld the stance. As of 2013 this remains the only Circuit Court decision on tax treatment of these payments. Relevant decisions by the United States Supreme Court, in a 2000 case, Vermont Agency of Natural Resources v. United States ex rel. Stevens, 529 U.S. 765, the United States Supreme Court held that a private individual may not bring suit in federal court on behalf of the United States against a state under the FCA. In Stevens, the Supreme Court also endorsed the partial assignment approach to Tam relator standing to sue, which had previously been articulated by the Ninth Circuit Federal Court of Appeals and as an exception to the general legal rule for standing. In a 2007 case, Rockwell International Corporation v. United States, the United States Supreme Court considered several issues relating to the original source exception to the FCA's public disclosure bar. The court held that the original source requirement of the FCA provision setting for the original source exception to the public disclosure bar on federal court jurisdiction is jurisdictional. The statutory phrase "information on which the allegations are based" refers to the relator's allegations and not the publicly disclosed allegations. The terms allegations is not limited to the allegations in the original complaint, but includes, at a minimum, the allegations in the original complaint as amended. Relator's knowledge with respect to the concrete fell short of the direct and independent knowledge of the information on which the allegations are based required for him to qualify as an original source. And the government's intervention did not provide an independent basis of jurisdiction with respect to the relator. In a 2008 case, Allison Engine Company v. United States ex rel. Sanders, the United States Supreme Court considered whether a false claim had to be presented directly to the federal government, or if it merely needed to be paid with government money, such as a false claim by a subcontractor to a prime contractor. The court found that the claim need not be presented directly to the government, but that the false statement must be made with the intention that it will be relied upon by the government in paying, or approving payment of, a claim. The Fraud Enforcement and Recovery Act of 2009 reversed the court's decision and made the types of fraud to which the False Claims Act applies more explicit. In a 2009 case, United States ex rel. Eisenstein v. City of New York, the United States Supreme Court considered whether, when the government declines to intervene or otherwise actively participate in a qui tam action under the False Claims Act, the United States is a party to the suit for purposes of Federal Rule of Appellate Procedure 4A.1a. The court held that when the United States has declined to intervene in a privately initiated FCA action, it is not a party for FRAP 4 purposes, and therefore, petitioner's appeal filed after 30 days was untimely. State False Claims Acts and application in other jurisdictions. As of 2014, 30 states and the District of Columbia have also created false claims statutes to protect their publicly funded programs from fraud by including qui tam provisions, which enables them to recover money at state level. Some of these State False Claims Act statutes provide similar protections to those of the federal law, while others limit recovery to claims of fraud related to the Medicaid program. The California False Claims Act was enacted in 1987, but lay relatively dormant until the early 1990s, when public entities, frustrated by what they viewed as a barrage of unjustified and unmeritorious claims, began to employ the False Claims Act as a defensive measure. In Australia, there have been calls since 2011 for legislation modelled on the False Claims Act and for their application to the tobacco industry and carbon pricing schemes. In October 2013, the UK government announced that it is considering the case for financially incentivising individuals reporting fraud and economic crime cases by private sector organisations, in an approach much like the US False Claims Act. The Serious and Organised Crime Strategia paper released by the UK's Secretary of State for the Home Department sets out how that government plans to take action to prevent serious and organised crime and strengthen protections against and responses to it. The paper asserts that serious and organised crime costs the UK more than £24 billion a year. In the context of anti-corruption, the paper acknowledges that there is a need to not only target serious and organised criminals but also support those who seek to help identify and disrupt serious and organised criminality. 3 UK agencies, the Department for Business, Innovation and Skills, the Ministry of Justice and the Home Office have been tasked with considering the case for a US-style False Claims Act in the UK. Rule 9(b), Circuit Split. Under Rule 9(b) of the Federal Rules of Civil Procedure, allegations of fraud or mistake must be pleaded with particularity. The application of the Rule 9(b) pleading standard to claims made under the False Claims Act, however, has generated much litigation, and there remains a split among the federal appeals court surrounding the specificity of the factual matter which needs to be alleged in order to plead a sufficient False Claims Act complaint. While the First Circuit and the Seventh Circuit have ruled that whistleblowers under the False Claims Act are not required to allege specific false claims to satisfy Rule 9(b), the Fifth Circuit, 11th Circuit, the Sixth Circuit, the Eighth Circuit, and the Tenth Circuit have all found that plaintiffs must allege specific false claims. In 2010, the First Circuit decision in U.S. ex rel. Dewberry v. Autobiotech Prods, LP, 2009, and the 11th Circuit ruling in U.S. ex rel. Hopper v. Sylvay Farms, Incorporated, 2009, were both appealed to the U.S. Supreme Court. The court denied certiorari for both cases, however, declining to resolve the divergent appeals court decisions. ACLUAL v. Holder, in 2009, the American Civil Liberties Union, Government Accountability Project and OMB Watch filed suit against the Department of Justice challenging the constitutionality of the seal provisions of the FCA that require the whistleblower and the court to keep lawsuits confidential for at least 60 days. The plaintiffs argued that the requirements infringed the First Amendment rights of the public and the whistleblower, and that they violate the division of powers, since courts are not free to release the documents until the executive branch acts. The government moved for dismissal, and the district court granted that motion in 2009. The plaintiffs appealed, and in 2011 their appeal was denied. Examples: in 2010, a subsidiary of Johnson & Johnson agreed to pay over $81 million in civil and criminal penalties to resolve allegations in an FCA suit filed by two whistleblowers. The suit alleged that Autumn McNeil Janssen Pharmaceuticals, Incorporated acted improperly concerning the marketing, promotion and sale of the anticonvulsant drug Topamax. Specifically, the suit alleged that OMJPI illegally marketed Topamax by, among other things, promoting the sale and use of Topamax for a variety of psychiatric conditions other than those for which its use was approved by the Food and Drug Administration. It also states that certain of these uses were not medically accepted indications for which state Medicaid programs provided coverage, and that as a result OMJPI knowingly caused false or fraudulent claims for Topamax to be submitted to, or caused purchase by, certain federally funded healthcare programs. In response to a complaint from whistleblower Jerry H. Brown II, the U.S. government filed suit against Maersk for overcharging for shipments to U.S. forces fighting in Iraq and Afghanistan. In a settlement announced on January 3, 2012, the company agreed to pay $31.9 million in fines and interest, but made no admission of wrongdoing. Brown was entitled to $3.6 million of the settlement. See also, Fr. John Karapi, Medicare fraud, Private Attorney General, war profiteering, making false statements. References. External links: The False Claims Act Overview, blog covering developments in the False Claims Act, Department of Justice presentation on University of Washington overbilling case from UW Public website, Taxpayers Against Fraud False Claims Act Legal Center, What is the False Claims Act? 1.